That's a gift to the other side, right? Not only are you biting off a retaliation case at that point, but you're also lending credibility to the allegation.
Corporate fraud works best in the shadows, behind corporate walls. How does the government bring these wrongdoers to justice? Whistleblowers. These are the stories of those who risk their careers to shine a light on allegations of fraud. Today on Fraud in America.
Well, welcome to today's episode of Fraud in America. We are now past 30 episodes, and we have never, ever had someone from the dark side. And our guest today promised me a Darth Vader mask. He's not wearing one, so I'm a little disappointed. We are having someone, a defense lawyer, join us to give us a perspective on the False Claims Act, the whistleblower litigation world from the other side. I recently, not too long ago, was speaking at a conference in New York City. And after my presentation, actually before my presentation, I heard our guest today, Eric Sitarchuk, talk about False Claims Act litigation from the defense perspective. Some of the things I did not resonate with me, but certainly there were some of the things in there that I thought were a perspective that I hadn't heard from in my 20 years of practicing. And I thought it was important for us to hear from a defense perspective on how these things work, how they play an important role in these cases. I oftentimes describe it as a three-legged stool, right? We have relators or whistleblowers and their counsel, and then we have the government. And that third leg is an important one, the defense counsel. So I asked Eric to join us today. He agreed to step into the lion's den with us. He is with the law firm Morgan Lewis, a very large law firm. He's based out of Philadelphia. He had served as lead defense counsel for decades in some of the nation's most significant criminal and civil False Claims Act and qui tam matters. He is a fellow Philadelphia Eagles fan. He has also spent some time inside of the government as an assistant United States attorney. Eric, thanks for joining us.
Jeb, thanks so much for having me.
So, Eric, why did you decide to go the route of becoming defense counsel?
Of course, Jeb, there was the matter of college tuition that had to be covered when I was in the government. So as much as I think virtually every former federal prosecutor just loves their job, when kids and tuitions come on the scene, one has to think about that as well. So I very much enjoyed being on the prosecution side of things. But chose the defense. And one of the reasons I chose the defense was I think that everybody plays a very important role in our system. And everybody contributes in the end to a just result. So I'm not one that's ever thought of people being on the right side or the wrong side. I think there's choices of sides, and it was whatever works for you and where you find your comfort zone. And I've always found my comfort zone after being a prosecutor on the defense side.
So what is the primary role of a defense counsel in a False Claims Act case?
So goal number one is to make sure you never hear about my best results for my clients. Your biggest wins are cases that no one ever hears about and that, frankly, you're not going to get a lot of credit for. So the best service I can provide to my clients is to persuade the government not to intervene in a case, and to, if I'm able to accomplish it, work with the government in explaining to a relator's counsel why it is that this is a case that, based on the merits and the equities, ought not to be pursued.
So why is that so important, to make sure that the government doesn't intervene or to convince them that this is a case that's not worth their resources? Why is that so important?
Well, a couple of reasons. One is that, if you have a shot at talking the government down off a case, then you probably also have a pretty good opportunity to explain to relators counsel why they should not invest a lot of their own time and treasure in pursuing the matter. So number one is, if the government starts to come around to your view as to why there's no there, it's a much easier job to do it with respect to relators counsel. On the other hand, there are many cases these days where the government does not intervene. but relators counsel chooses to pursue the case. They may have a different view of the case than the government. The government, for policy reasons or resource reasons, may decide not to pursue a case. So you may still be left with litigation against the relator. And frankly, there, from the perception of the defense, there's a much more even playing field in most courtrooms if you're litigating a non intervened case against a relator than an intervened case against the United States.
This is an interesting point. Certainly in the last 10 years, we've seen this play out in just about every single case where the government, where they make the decision not to intervene, they will let the relators and the relators counsel know why, right? And sometimes it's this whispered down the lane. Well, defense counsel explained to us, from their perspective, and we agree with their view. Other times, the government will say, we just simply don't have the time, money, and resources to invest in this case, but we encourage you to go forward and litigate this case against Morgan Lewis. You guys have the ability to go forward with this case without us. So, Eric, when you find out that there's a relator or a potential relator in the case, how does that color how you advise your client to proceed?
Jeb, that's a sort of a multifaceted issue, and let me try to approach it from a couple different directions. The
Sure.
first is that often the first way a defendant learns about a matter is obviously when they receive a CID or a HIPAA subpoena or something of that nature, right? And one of the things that you try to do early on, sometimes it's a bit of a game just out of curiosity, but it also has some tactical merit behind it, is to try to assess A, whether there's a relator, and B, who that might be. Because part of the job of a defense counsel is to kind of try to get in the government's head and almost to be in a position to answer their questions and address their concerns about a case before they're even asking them or expressing them.
Mm.
Because I found that sort of really resonates with the government. They have something in their mind. They know it's bothering them. Hasn't quite articulated the theory yet. And if you're out in front of that and addressing that, then you're making significant progress in terms of causing the government to take a look at the case from a different perspective, raising some questions in their minds. And identifying who the relator is often can give you a clearer sense of what the issues are rather than just looking at the CID. Because most cases, at least that I've found, is that relators, particularly in False Claims Act cases, they didn't join the company because they wanted to hit some sort of False Claims Act lottery, right?
Mm.
They're in
Yep.
there to get their job done, do the right thing, do it in the right way. So if they have concerns, they've typically raised them internally first. And perhaps the company has already addressed them. Perhaps the company did not address them for a variety of reasons, but either way, it's important for me, if I can figure out who the relator likely is, to take a look at, have they raised concerns in the past? What were their concerns? How did we address those? And that gives me the ability to go back and start to have a dialogue with the government about what the case is all about. So that's one of the reasons why it's important to sort of know who your relator is up front and start to think about who your relator is up front if you can.
It makes a lot of sense, right? It allows you to have some look into this complaint that's under seal and the allegations or evidence that the government might have. If you have some idea or a good idea who the relator is, what do you advise your client to do at that point?
If the relator is still employed by the client, a couple things. One is don't do anything that could even create a scent of retaliation. But at the same time, let's make sure that we have their email secured. Usually are by that time anyway, because you've probably issued a pretty comprehensive records hold. But also let's keep an eye on their computer activity, their IT activity, to make sure that no documents are being taken, nothing's going out the back door, something of that nature. So it's sort of a dual role. One is be very, very mindful not to do anything that could even create the impression of retaliation, but also keep an eye on things to make sure that company confidential information isn't being accessed or dealt with in an inappropriate way.
That is the part that really caught my ear. You made similar comments up in New York City. It's not the playbook that some defense counsel play. Why do you think that's a mistake? The people who just say, find out who that relator is, and we want them out of our org chart ASAP? Why is that the wrong approach?
To me, frankly, that's a gift to the other side, right? Not only are you biting off a retaliation case at that point, but you're also lending credibility to the allegations. And look, job one for me is to walk into the government with credibility that's equal to the credibility that relator and relators counsel have. And two is to sit down with the government and start to have a transparent dialogue about what the facts are. It's very difficult for me to do that if it looks like my client is in the process of retaliation in the meantime. That not only creates a retaliation case, but it also lends some pretty significant credibility to that there may be a there and that my client is not acting as they should. So to me, it really harms my ability to have an effective dialogue with the government.
I couldn't agree more. We oftentimes talk about relators or whistleblowers as the should have been employees of the month. That they say, in the mountain of regulations that we're supposed to follow, we're violating this one right here. And they highlight it. And too often the company makes the decision to alienate, isolate, or terminate that person. And then they call us. So to hear this approach, I think is really important for people to hear who might be thinking about becoming defense counsel. That this approach certainly, I think, would be welcomed by relators counsel, and certainly the government, to hear that you're approaching them in a way that honors their concerns as opposed to telling them to go on their merry way and put everything they own in a box. And looking back over your career and seeing the trends, especially in the False Claims Act arena, what are some of the things you've noticed?
There's been kind of an overall arc from what was sort of pretty in the beginning, a fair amount of pretty brazen fraud, just kind of upcoding, classic overbilling, what I sort of used to refer to as real fraud. And now you're going to see the defense attorney in me. Over the years, as compliance programs really came into existence and then started to become much more effective. And as companies really got the compliance message, I've found that the vast majority of companies, and certainly the sophisticated ones, want to get it right, want to do the right thing. They don't need the distraction, the reputational damage, and the expense of government investigations and whistleblower litigation. It's not good for business. So as a result, they've gotten their houses in pretty good compliance order. And therefore, the issues that have come out over time have been grayer and more complicated and more deep into trying to figure out what the obligations are under a complicated regulatory scheme. So that's sort of number one. Number two is a little bit of the regulation by False Claims Act, which is that DOJ, with the help of creative relators lawyers, will identify what they think are certain ways in which perhaps the industry shouldn't operate, but the legislature hasn't said you can't do it. So they look for sort of creative False Claims Act theories in order to take a position with respect to regulations that either wasn't clear or, from our perspective, wasn't intended. So I'd say the cases have gotten more complicated, more sophisticated, and a lot grayer.
Interesting. My wife is a chief medical officer of a health system. So it makes for interesting dinner time conversations. And sometimes she does dive into that area. But, we also talk about that there are certainly this pressures, economic pressures put on all players, especially in the healthcare setting, to continue making a profit. And the gray areas sometimes are viewed as opportunities by competitors to shift the playing field. And where that line is drawn is sometimes hard for defense counsel, I'm sure, to play, but also for relators. And sometimes when we put on educational seminars, when people ask, is this a False Claims Act violation? I'm left with saying, well, does the government care? We call that materiality, and for a long time we refused to admit that was even part of the False Claims Act. But at the end of the day, does it even matter, right? If you tell a jury about what happened and they're left with this so what feeling, then is that really worthy of our time, money, and resources on the relator side? I'm guessing you guys have a similar view.
When you think about a jury, these are tough cases for both sides, and I think that's why the vast majority of these cases settle. From the perspective of the defense, I mean, the concern is frankly that particularly in areas where there's a high volume of billing, like healthcare, the
Mhm.
potential downside is it often enterprise threatening in terms of what a verdict might look like when you look at not only treble damages and theories of forfeiture of the entire bill, but then when you talk about the penalties per almost per claim for reimbursement, the stakes get very high. So defense counsel is looking for ways to get out of cases, obviously, or to resolve cases. But I think relators are as well. And I've taken, a fair number of cases up through jury exercises, and, you're about to walk in the courtroom and a deal is cut. And one of the things I've heard afterwards is that we both kind of have similar experiences with our jury exercises. We see that our defenses are resonating, but then if we do, and obviously you do a number of these, but if you get a bad result, the damages are through the roof. But relators counsel, on the other hand, I've heard them report back from time to time that the juries are like, well, yeah, so what? I mean, these guys got to make money too, and they are providing the services and they are providing the healthcare needs. So why are we here? So I think that for both sides, there are challenges in these cases with regard to their complexity and their dryness. And the fact that often we're talking about not a question of whether services were provided or services were provided well, particularly in the more complicated cases, but really how do you interpret a regulation that doesn't make a whole heck of a lot of sense to start with sometimes.
So I noticed in your bio that you also do FCPA work. You also do a bunch of other things. One of the trends that I certainly have noticed is it used to just be False Claims Act. Now we see SEC, IRS, CFTC, soon the FTC. Everybody that has an alphabet now has a whistleblower program. How has that impacted how you approach these cases?
The non-FCA cases really present a kind of a different structure, right? Which is you don't have someone bringing a case on behalf of the government and have the ability to pursue it if the government decides not to get involved. But you're in a situation really where you have more of tipsters. They're bringing information to the government, but ultimately the government has to decide to pursue the case. And if they don't, there is no case, right? So in some ways, the approach is the same. It's an approach
Mm.
of transparency. It's an approach of what do you how do you get a constructive dialogue going with the government. It is some curiosity about the whistleblower, which is more than just curiosity but can drive your tactics. It also kind of drives the equation of how do you deal with internal problems, right? If you find an internal problem, you obviously you want to address it, you want to remediate it, you want to make sure that it's not continuing. But do you go to the government affirmatively? And in the old days, from the defense perspective, there was kind of a view, well, we'll take care of it internally. We'll fix the problem. We'll cut off any ongoing misconduct. We'll do a lot of remediation to make sure this kind of thing doesn't happen again. But if we don't owe any money to the government, if there's not an affirmative obligation to repay, which changes the equation, do we really need to go to the government and disclose this, or can we just take
Mm.
care of it internally and move on? With all the whistleblower incentives out there, that has made that calculus more complicated, and has really caused one to have to take a very hard look as to whether this is an issue that we ought to affirmatively go to the government to and voluntarily disclose.
Fascinating. Do you want to know at some point who the Relators Counsel is on the other side? Does it change your calculus or the way you approach the case in any way? If you hear that somebody on the other side has a history of going forward post declination without the government, does that in any way change your approach?
Yeah, I do want to know who the Relators Counsel is for a variety of reasons. One is that if it's sophisticated Relators Counsel, experienced Relators Counsel, and the case has some fundamental flaws, then I'm going to want to pick up the phone and talk to them about it and have a dialogue with them. To because they don't want to throw good money after bad. They want a continuing relationship with the government that's a positive one and not to send the government down rabbit holes. So, it's important in that regard. I also want to be in a position to explain to the client what I think is going to happen if the government's not going to intervene. And if it's a relators counsel that has a history of pursuing cases irrespective, or if it's a relators counsel that's effective in sort of building a consortium of law firms to tackle bigger cases and spread the pain of the investment, then I'm going to want to know that too, because our government, our clients want us to have crystal balls, not only with respect to what the government's going to do, but what relators counsel is going to do. And none of us have crystal balls, but we want to sort of do the best we can in trying to get the client to understand what the likely scenarios are.
Years ago, Professor Pam Busey published this article. The theory, the title had the words game theory in it, but basic idea was she was looking at the False Claims Act world, and she saw several repeat players, our side and your side especially, and the idea being that we weren't going to do something that was going to tarnish our reputation with the government, because the next week we're coming in with another case with a different relator. And the same thing with defense counsel, that they weren't going to look to do something that's off the wall, because of the next week they're coming in with another client that might be facing, and you don't want to put yourself in the category as being, oh great, here's another complaint from Jeb White, we know this is going to not have water, not going to hold water. Does that hold true for your side as well?
Absolutely. I mean, you're playing the long game here, but the long game doesn't sacrifice the short game, right? Because you want to maintain your credibility. You don't want to do anything in an individual matter that undercuts your credibility in the next matter. But at the same time, that doesn't mean that in the instant matter you're doing anything that you wouldn't otherwise do, right? Because the credibility that you gain through past conduct and that you gain through dealing with the government in that particular matter is going to serve you well, because the best way to convince the government to walk away from a case is to be able to demonstrate to them what the flaws in the case are, and for them to understand that when you say there's a flaw, there's a flaw. You're not blowing smoke.
So, Eric, you have been at AUSA, you've been defense counsel. Now I'd like for you to think about, if you were to be a relators counsel, how would you approach this practice?
Well, Jeb, I got to say, every time that any defense counsel participates in a case that results in a very large settlement, we do think about what it would be like to be on the other side. And we scratch our heads a little bit about whether we picked the wrong side of the V, but then we move on to the next case and we're satisfied and happy where we are. But we do think about it from time to time. And boy, I got to say, relators counsel have a tough job, right? Because first of all, as I think about it, when I see all the kind of inside companies, the issues that come up through the compliance programs, the allegations that are made, there are so many times when when the alleger is acting in complete good faith, they just don't get it. They have sort of a myopic view of their own world. Sometimes they're someone who really kind of, if someone disagrees with them, they assume the worst about that person. So to me, the vetting process must be challenging, and it would be something that would be for me a very important part of the original task, is to really understand what the potential client has, why they're coming to me with it. Now, on the other hand, on the government side, I always enjoyed investigating, putting together the puzzle. And I think that would be, I think for relators counsel, that to me is one of the more interesting tasks, challenging tasks, but a satisfying one, to take pieces of a puzzle, try to match it together and see if a picture emerges of something that's worth pursuing.
I think you put your finger on perhaps the most important role that we play, that vetting process of calling through a lot of stuff and identifying really the most actionable violations of the law. It's perhaps the most important role we play. Otherwise, the government would be the proverbial needle in the haystack in every single case. It simply doesn't play out. And certainly good relators counsel play a good job in making sure they're vetting the best cases possible. So, Eric, where do you see the law heading in the next 20 years?
We as defense counsel, we wonder whether, you always wonder whether Congress is going to do things like clarify or narrow the impact of Escobar, or other pro-defense decisions. So, we wonder that on that side. On the other side of the coin seems to be a very conservative and pro-business Supreme Court that is willing to take positions that favor the business side of things, even contrary to the position of the government. So we wonder whether we'll see sort of a tension between the Supreme Court really narrowing the False Claims Act and then Congress trying to push back against that, and how that's going to balance out. I do think that the relators bar that has developed is, so I'm going to blow a little smoke at your audience, Jeb, but this is true. It has become very sophisticated, very well funded, and has been that way for quite a while. And we also see as a trend lawyers in the plaintiffs bar that had traditionally limited themselves to large products matters, class action matters, things of that nature, getting into the whistleblower side as well. So there's a very, very talented whistleblower bar out there that's looking at creative new theories. And I think that what we'll see is, as more and more industries are out there doing significant business with the government, not just the defense industry, we're going to see a lot more cases on the procurement side. As we continue to see federal funds go into various areas, infrastructure, like we saw with the TARP funds before, key TAM and False Claims Act cases in industries that really hadn't seen them before. We saw it in the banking industry with TARP funds. Never thought you'd see False Claims Act cases in the banking industry, but you saw a lot. So I think we're going to see kind of a back and forth on the scope of the law between the increasingly conservative federal judicial bench and Congress. And so long as Senator Grassley's still in place, there's going to be a hard push to counteract any narrowing by the courts. And I think that we're going to continue to see more creative theories brought against a much broader variety of industries than the traditional defense industry and healthcare industry.
I agree with everything you just said. As money flows, fraud follows, and the influx of funds especially since the pandemic, is ripe for fraud. So it's going to be interesting few years. A lot of those cases are, of course, under seal right now. And I would say, the maturation of the defense bar and the specialization of the defense bar on False Claims Act, I've seen over the last 20 years, and it's made for a lot of fun in the courts, and certainly on the Hill as we try to protect the False Claims Act. And your side tries to maybe narrow the False Claims Act in certain ways. So it should be a fun time over the next 20 years. Eric, any parting words?
Jeb, I very much appreciate the opportunity to talk to your audience. This has been terrific, and I guess my parting word is that sometimes we look at the other side and we look at the sort of darkest aspects of their motivations. When I think that we'd be surprised to see how much common ground we have. And there's often opportunities to get to the bottom of matters quickly and transparently. That can benefit all of our clients. Where, look, if we have a problem, we want to know about it. We want to deal with it. We want to fix it. We want to move on. If you guys have a case that's not as good as you thought it was, you want to know the same thing. You don't want to throw good money after bad. So there's a lot of common ground there, which we can continue to work with to the benefit of all of our clients.
Amen. You're going to want to go to taf.org to make sure you sign up for our newsletter. We also put out notifications about upcoming episodes of Fraud in America. Eric, thank you so much for joining us today.
Thank you, Jeb. Appreciate your time.
We hope you enjoyed today's episode of Fraud in America. Today's episode was made possible because of the generous donation of longtime TAF supporter and whistleblower attorney David L. Herron. If you believe you have witnessed fraud against the government or fraud on the financial markets, we encourage you to visit our website at taf.org, where you will find a directory of member attorneys who represent whistleblowers across the country. On our website, you will also find additional information about our nation's various whistleblower laws and programs, and a way to donate to our organization as we step forward in spreading information about whistleblower programs. This episode was edited and produced by Rachel Brooks, and our theme song is by Connor Chaos. A big thank you to our TAF staff and researchers of James King, Emma Bass, Jackie DeMar, Kate Scanlon, Max Boldman. Fraud in America is a project of Taxpayers Against Fraud Education Fund. The opinions expressed on today's show belong solely to the guest and are not necessarily endorsed by the organization. Thank you for joining us on today's episode of Fraud in America.